Now we are on, and all the stuff I just said was, hi, I'm Karen, this is Bobby, Steve's over there, and we're gonna do Title IX training. So all the other introductory stuff I said for the last minute, I guess doesn't really matter. We are recording today's webinar, and so you will be able to access that recording on our website, and we'll leave that up indefinitely. We'll also have copies of the regulations on the website, copies of the slide deck, which you should have already received. We made a couple tweaks, and Steve said he found some typos last night, so blame Steve for the typos if he found them. But all that will be on the website in a recording form, as well as stuff that you can download. When we do the recordings, I post it as one long 3-hour chunk, and then I also try to chunk it up by topic so that if you remember, oh shoot, I wanted to know about XYZ, you can just go to that topic. And I'm curious if that's useful to you all, because we want to make sure that these webinars are good. We crave your feedback. So if you find that useful, let us know. If you find that to be not useful, let us know. One of the things I like about doing webinars is that you all can be in the comfy, cozy area of your office or at home and not have to be out on the roads and coming to see us. One of the things I don't like is it's really hard for us to know if we're connecting with you or not. And so we really do want you to text us questions, comments, concerns. This is Steve's cell phone number today. He's going to be handling, collecting the text messages and then asking us the questions. But you can text all along. You don't have to wait for a formal break. You can text and then we'll answer as they come. But we also will have specific times that we take breaks. Last thing, if you're watching on Zoom and you've got like a Hollywood Squares situation happening, if you want to see that, that's great. If you don't want to see that, you can slide down and pin the video of us. And the way you do that is you run your mouse down to where you see the video of us and highlight that little square. On the upper right-hand corner, there's 3 little dots. Click on that and you can select pin video. If you want to see the slides and us side by side, which is what I would want to see if I was watching it, you can go up to the top of your screen where it says screen sharing. There's a little thing that says view. Click on that, and if you pull it down, there's an option to select side-by-side view, and that would get you the slides and the video side-by-side on your screen. If that doesn't make sense to you, someday maybe I'll do like a little webcast on how to do that. But so that's the last little housekeeping thing. Okay, so my job for the next few minutes is to give you the basic overview of Title IX. Most of you know a lot of this stuff, but in order for this to be qualified training for Title IX coordinators with the Office of Civil Rights, we have to do some of this initial dancing. One of the things you're going to hear us refer to over and over again is OCR. If you don't know, and don't feel bad, a lot of people don't, the Office for Civil Rights is an arm of the U.S. Department of Education. They are charged with making sure that every educational institution that receives federal funding complies with all the federal anti-discrimination laws. Title IX, Section 504, the prohibition against discrimination on the basis of race that's found in Title VI and other places. And so when the Office for Civil Rights comes calling, by definition, they're saying, if we don't like what you're doing, we have the ability to withhold your federal funds. Now, OCR hasn't done that except in one instance. They withheld a portion of federal funding from Chicago Public Schools last year, but they don't willy-nilly withhold your federal funding. But one of the reasons you're going to hear us talk about the Office for Civil Rights and our concern about OCR investigations for the next 3 hours is they're pretty aggressive in telling schools what they want schools to do, because they know that they swing this enormous stick. We're probably going to do whatever they ask us to do. So that's OCR. OCR has different offices across the country. We are the Kansas City region, which is actually good news because they are a region that's pretty good to work with. We have really good relationships with most of the OCR investigators that get assigned to come to Nebraska schools. But the problem is we can kiss up to them all we want. It's the higher ups in OCR that have sort of set the policy direction for how they're going to enforce these statutes. So with that said, Title IX is a federal statute that prohibits discrimination on the basis of sex. If you have the slides printed out, I always circle sex because as we talk, it's going to get farther and farther from like what the heck is sex. We had a long conversation last night about like locker room, if girls are misbehaving or boys are misbehaving in the locker room, is that on the basis of sex? Is the fact that they are sex segregated into locker rooms make everything that happens in a locker room automatically a Title IX problem? There are people at OCR that would say yes. The same thing goes for whether or not you're gay, whether or not you've had sex, whether or not you're pregnant. All of that stuff to me didn't initially flow from the idea of sex. To me, sex was, you can't have this job because you're a girl. But the definition of sex, as the federal regulations have interpreted it, is way broader than just biological sex. So no discrimination on the basis of sex in any education program or activity. Programs make sense. You cannot tell a girl that she's not allowed to take math. Activities is much broader, which includes sports, which most of us have figured out, but it also includes things like the summer trip that the band takes to go to band camp to learn how to do the choreography for marching band, and a whole bunch of stuff that doesn't touch as directly on the school as you might think. And then the last thing is federal financial assistance. Everybody listening today is a public school, so y'all get a ton of federal financial assistance in the form of special ed, even if it's not as much as they promised us, school lunch, title funds. There's really no way for us to say that we don't receive federal financial assistance if you're a public school. So what is discrimination on the basis of sex? The regulations say it's anybody that gets treated differently based on the person's sex. Notice that first bullet point. I don't want people to think that if you have to do a Title IX investigation or if a school has Title IX issues, that doesn't mean that you're inherently a sexist or a misogynist. It doesn't require any particular hostility or intent. A simple difference, inadvertent difference in treatment is enough. There's a great case from Bobby's alma mater, where a boy wrote in his yearbook that his hobbies were Netflix and chill, which, if you are not up to speed on all the Urban Dictionary slang, basically is like, come over and have casual sex. The boy wrote that in his yearbook biography. A year or two later, a girl wrote that in her yearbook biography. The principal of Bobby's old school says, I didn't know what it meant when the boy wrote it, but I know what it means now that the girl wrote it, and so he told the girl that that was not okay. Huge Title IX lawsuit, because the girl is saying boy was permitted to say that, she was not. And this subpoint is what's gonna really hurt the principal, I think, in Bobby's school case, because the fact that he wasn't intending to treat the girl differently because she was a girl may not be enough to get them out from under Title IX liability. Next bullet point, it includes sexual misconduct. You've probably heard all the news about the new regulations and the rape culture on campus and how some young men on college campuses think they're being railroaded by false allegations of sex assault. And you're saying to yourself, sex assault is a crime. Why is this a Title IX issue? That's because sex assault, sexual aggression, sexual misconduct all falls under that broad definition of on the basis of sex. It definitely includes gender stereotyping. If you're saying to yourself, man, Karen sounds like a bitch, that is gender sex stereotyping. It also may be true, but it's stereotyping. And so that's obvious. Sexual orientation and gender identity is probably included in the definition of sex. The reason we say probably is, you know, sexual orientation is not specifically a protected class under Title VII. And in Nebraska, we have a constitutional amendment that specifically says we are not permitted to treat sexual orientation as a protected class. But if the way they get there under Title IX is they say, if you assume that women only have sexual attraction to men, you are sexually stereotyping women. So it's not that we're protecting gayness, it's that we're protecting non-stereotypical definitions of sexual attraction. And then gender identity, we'll talk about transgender later, and you'll be sick of it by the time we're done. Some of the key terms under Title IX that you're gonna wanna be able to fling around as you do Title IX investigations. Unwelcome conduct is something that can be done by an employee or a student. Most people understand that. It also includes third parties. So if you're doing a construction project at school and the construction crew is catcalling girls as they walk into the building, that's a Title IX problem for you, even though you don't employ the people that are working on the construction project. Of a sexual nature, which includes sexual advances. It includes the creepy teacher that sleeps with girls that we're going to talk about, the creepy female teacher that creeps on boys, also included. Includes both nonverbal and physical contact of a sexual nature, whether it's consensual or not. If the person who is being contacted, the person in the one down position of the relationship, somehow feels compelled to be engaged in that relationship. And then it includes non-sexual gender-based conduct like calling somebody a bitch or a whore, hostility based on sex or gender. This is the idea that rape and other forms of sexual violence are a Title IX problem. Again, sex harassment is more than having a pinup girl calendar in the shop. It includes things that are actual crimes under the Nebraska Criminal Code. And so all of this is included. One of the big mistakes schools make is when there's an allegation of sex assault, they call the cops and call it good. What we're going to tell you today is you do have to call the cops, but then you have to launch your own independent Title IX investigation, because Title IX sex discrimination includes sexual violence. Throughout this deck, and hopefully you got the slides yesterday or Thursday when we sent them out, Friday when we sent them out, and you've printed them or had a chance to look at them, you'll notice at various times throughout the deck, the type is in green. Anything in green is going to be in reference to new regulations that have been promulgated and proposed by the Obama administration and the Education Department and the Education Secretary, Betsy DeVos. So what's happened when Trump was elected, one of their policy focuses was to make sure that people accused of sex assault had adequate due process before they were punished in some way in an educational context, separate and apart from a criminal context. So in 2007, Betsy DeVos said, we're going to stop, and you guys will remember all of those Dear Colleague letters that came out during the Obama administration, and we were constantly scrambling to figure out like what the new enforcement protocol was under this or that Dear Colleague letter. Whatever you think of the Trump administration or the Betsy DeVos portion of the Trump administration, I like, as a school lawyer, that they have decided that they are not going to make rules just simply by sending out a letter anymore. And so she announced this change in policy in 2017. And as part of this, they rescinded a whole bunch of old guidance that had been in existence under the Obama administration. I think this is the 4th year that we've done this statewide Title IX training. A lot of the old decks that I went through as I was looking to get ready to put this deck together, a lot of those old decks include guidance and advice based on letters and rules that are now rescinded. So anything that refers to a Dear Colleague letter other than the one in 2001 and 2014?
2001.
14 was rescinded. Anyway, so I mean, all of the stuff that we've talked about over the years, the special focus on pregnancy, the special focus on girls of color that were struggling academically. I mean, as you've heard me talk about these issues over the years, all of those Dear Colleague letters are now gone, like they never happened. And so the green stuff will be what they're proposing that is now new. The black stuff is what is the law, and we don't reference or rely on any of those rescinded letters and any of the stuff we put together for you today. This is now right after Betsy DeVos said we're not going to make rules based on letters. They released a letter that is a question and answer document about on-campus sexual misconduct. This 2017 letter was in effect when we did last year's Title IX webinar. So if you heard me talk last year about this, that's still good stuff. And some of the guidance or advice that we're going to give you today is based on this Q&A letter. This is something that if you receive an allegation of sex assault, you should probably be familiar with or know to go download this to keep an eye on it as you do that investigation. So the most important thing that came out of that September 2017 question and answer is the Department of Education from DC now says every school district has to make 2 choices in what they're going to do on Title IX issues. First, the board has to decide whether you're going to say we're only going to punish kids for alleged sex assault if the evidence is clear and convincing, or we're only going to punish kids if the evidence is a preponderance of the evidence. I'm going to explain what those 2 things mean, and then I'm going to explain why this is kind of a false choice. So clear and convincing is if you think of it in football analogies, beyond a reasonable doubt, I think of as you got into the red zone on the football field. Clear and convincing is you're in field goal range, right? You're about the 30-yard line. It's a heavier burden. Preponderance of the evidence just means you crossed midfield. You got to the 51st yard line or the 49th yard line, however you're thinking about it. So you have to decide how much evidence you're going to need to decide that somebody actually has violated Title IX if you're going to punish a kid. The problem is the guidance also says that they expect schools to use the same standard, clear and convincing versus preponderance, for all of your disciplinary rules. So if you say to yourself, or if the board says, we want to make super certain that before anybody is punished for sex assault, we have clear and convincing evidence. We want that higher standard. That means that before you can punish somebody for juuling, you also have to have clear and convincing evidence. What they say is it has to be the same standard for all disciplinary things. Most schools just use the preponderance of the evidence. Hey, you touched her, get on the wall, no more recess for you. That's enough, right? We don't have to have clear and convincing evidence. And so if that's the standard that you want for other disciplinary decisions, that's the standard that you have to use for Title IX. So we offered this to policy service subscribers, this choice last year, and every single one of our subscribers selected preponderance that I'm aware. I don't know of anybody that's selected clear and convincing because of the implications it has for your regular student discipline. So that's the first choice you have to make. What's your evidentiary standard, clear and convincing or preponderance? The second choice that you have to make is, are you going to allow people to appeal decisions of discipline based on Title IX allegations? And if you let one side appeal, you have to let the other side appeal. And again, most schools already have a little process that you can go up and tell the superintendent did something wrong, and then the Student Discipline Act allows you to ultimately go to the board. And so allowing those procedures hasn't really been an issue for schools in Nebraska, but knowing that these choices exist will help you understand the new regulations a little bit. So on November 29th, 2018, the U.S. Department of Ed announced their new regulations. They were published in the Federal Register, and then they gave 60 days to interested parties to make comments. There are a ton of comments that have been submitted. KSB talked about submitting comments, and we finally decided that we were just going to be one voice that was sort of like background noise, and they wouldn't really care what we said, so we didn't. But that doesn't mean we don't have some real definite thoughts about these proposed regulations. The comment period is over, which means the Department of Education could say that these regulations are final any day now. They are not final yet, and based on the volume of comments, I really think there are a few things they're going to tweak, but I think their overall philosophical approach is probably going to stay the way it is. So although we can't tell you everything that you're going to have to know about the proposed regulations today, we're going to point out some issues that you're going to need to start thinking about. Now, assuming that these regulations get finalized yet this school year, we will do this Title IX webinar again next year since we have to do it annually, but we will do it early in the school year so that you can get trained up on the new regs once we know what those regs actually are. Are you wanting to say something?
Nope.
Okay. So if you are on Twitter, you saw yesterday that Karen Hassey's two legal worlds collided as Title IX and digital citizenship met in the middle of a Husker football. Maurice Washington is a football player for the University of Nebraska, starting wide receiver, or starting running back, and he is from California. He was alleged when he was in high school to have a video of his ex-girlfriend having sex with two of his peers. She says she was raped. They say it was consensual. Who knows? What is alleged about Maurice Washington, however, is that he had a copy of that video and that he sent a copy of that video to the girlfriend sort of to get back at her for breaking up with him. Now, the University of Nebraska yesterday released a statement that said, we are aware that this is happening. We don't think there's any other investigation that we need to do right now, but we're cooperating with law enforcement. Basically, it was a big nothing statement that they released. Question is, under the new regulations, would this be enough for the University of Nebraska to simply release a statement? And I'm not sure it is. 100%, I have no doubt that if another girl in Lincoln or California were to allege that Maurice Washington did something inappropriate towards her, whether that be dating violence, revenge porn, sending an inappropriate, dick pic, what Bobby calls junk mail, any of those allegations would be enough under the new regulations to trigger a mandatory complaint by the Title IX coordinator at UNL and a mandatory Title IX investigation that would have to happen at UNL at the same time the criminal case is going on in California. And these same rules now are going to apply with equal force to K-12 educational institutions.
I was just going to add a couple of quick things. Number one, I think he's actually facing indictment now. I think there's a warrant even out, or they've asked for a warrant to be able to bring him in and ask him about this stuff. So it's going to get interesting from that regard. I wanted to say, in Nebraska, we don't have what's considered a revenge porn law necessarily, but I believe there were 3 that were introduced this session, different versions of what would be considered revenge porn. This concept of, I have an image, whether I got the image directly or indirectly of this victim or person, and then I use that image to do something to get them, either to do something they don't want to do, to shame them, or for some other reason. If you read how California's law is set up, it's super broad. But even more than that, I think what people aren't necessarily considering, and why we like coming to schools and giving these presentations, is the possession on that phone on his phone for 2 years, even though he wasn't in the video.
Yes.
Is possession of child porn.
And that's the point I wanted to make,
Yes.
that it doesn't matter that there's a revenge porn statute in Nebraska or not. He's also being charged under the child pornography statutes. Those of you that have been in your school, or Bobby's been in your school, you've heard us talk about this to kids. And Maurice Washington is being charged exactly the same way that we talk about kids being charged in Nebraska for possession and distribution of child pornography, because having the video on his phone, he's in the active commission of a felony.
So one of the ways that we've been talking about this here, and we'll talk about it as we go through this, is, okay, so we get a call about a certain situation, or you read about a situation in the newspaper. How will this work under the new regulations? And so that's why we've titled it this way, and that's why we've sort of got the presentation set up. Here's what we've always known about Title IX, and here's what the new regulations would do. Because I think this is a perfect example of a case that if you're somebody who is thinking, okay, well, how will this be different? Or you have an experience this year of a girl that says, I sent this picture to my boyfriend 3 years ago. We broke up. I know he sent it to somebody else. If he sent that to 2 other people, there is a chance that you would have considered that one incident, right, to investigate. But under the new regulations, you, as the coordinator, might have to affirmatively file a complaint against that person because you've got 2 acts of it occurring.
Even if the girls in the picture say, I don't want you to. Right. And so that's like the new regs are kind of a nightmare. But even under the old regulations, I believe that you would be required to at least begin the investigatory process to see if there are Title IX implications to a sexting allegation going on. Those of you that I've worked with on sexting cases, you always hear me say, make a note on your calendar, 6 weeks from now, follow up with the victim. That's because Title IX requires that follow-up, whether under the old or the new regs. So your general duties under Title IX, when you have noticed that there's sex harassment or sex violence occurring, your duties spring into place. And that includes gossip, innuendo. I mean, you can't like be willfully blind to things that you're hearing about happening. Now, under the new regulations, one piece of, there's a lot of potentially good news in these regulations. You've probably heard in the media how horrible they are, and we're gonna certainly complain about a lot of aspects of it, but there are some good things about the new regulations, and this is one of them. The new regulations say that we are only going to hold schools accountable for violations of Title IX if the school district is deliberately indifferent to sex harassment and if it has actual knowledge of whatever is going on. The old OCR, the Obama OCR, had a standard that says knew or should have known. So even if you knew nothing about the dick pic that was making the rounds in the 8th grade class, if kids were giggling and somebody was crying in the bathroom and people were talking about, strange pictures going around, that may have been enough to trigger your obligation because you should have known. Now the deliberate indifference standard is you actually had knowledge and then chose not to take any action. So that is a change for the better under the proposed regulations. So once you receive this notice, once you know something is cooking, you must take prompt and effective action to end the misconduct, to prevent its reoccurrence. Quick footnote. Number 1, please notice that this is different than calling the cops, right? Calling the cops is punishing the misconduct. This is a whole different frame of reference. This is looking forward to say, we're gonna make sure this doesn't happen anymore and make sure it never happens again. The focus of the criminal justice system is punishment. The focus under Title IX is remediation and prevention of reoccurrence. In general, when you know something's going on, you have to conduct an investigation. The good news is, under the current statutory regulation system, that investigation is kind of like whatever you feel good about. The new regulations, that's where the big changes occur. And then you're also supposed to institute remedies as appropriate. You're supposed to also follow up with the victim to make sure he or she is not continuing to suffer a deprivation of educational benefit. The old guidance said 60 days. The letters that said 60 days have all been rescinded by Betsy DeVos, but OCR seems to still be expecting a prompt response that they define as within 60 days. You're never going to go wrong by hitting that 60-day benchmark. If you go beyond the 60 days, if it takes you more than 2 months to investigate, you better call your lawyer. I think you probably should call your lawyer earlier anyway, but if you're going to go beyond 60 days, you better have legal advice to make sure that you're still having a prompt investigation. Now, hopefully everybody that's listening to this webinar knows either if you are the Title IX coordinator, or if you're not, who the person in your school district is that's the Title IX coordinator. The regulations require every school district to designate one employee to be the Title IX coordinator. We had questions from ESUs several years ago about whether or not they could contract out to you to have somebody at the unit be your Title IX coordinator, which would be awesome, except you see the regulation specifically says it has to be an employee. So you can't contract that out to some third party. OCR wants the coordinator to have knowledge of policies and procedure, to be involved in the policy adoption or revision process, to receive annual training, whoop, whoop. And they recommend that the Title IX coordinator not be the superintendent. Now, this comes from a Dear Colleague letter that was rescinded, but I don't see any of these requirements changing except the last one. But with the new regulations, we had an email from Fred Hansen, who's a gunner and had already read the materials. We are not sure here internally if the new regulations go through as passed. I don't think you're gonna be able to have the superintendent be the Title IX coordinator anymore.
Well, that's one of our questions here. Okay, then in small schools, who traditionally has been the Title IX coordinator?
We have spent a lot of our time since November 28th and the new regs coming out, the proposed regs coming out, a lot of our time trying to figure this out. We will, once the regulations are finalized, we will have better, more firm advice. As I stand here today, I think your best bet is probably going to be, if you are a school that has one superintendent and 2 principals, I think your best bet is probably going to be that the elementary principal is the Title IX coordinator for the high school, and the high school principal is the Title IX coordinator for the elementary, and the superintendent sits over as the person who's able to make decisions in these investigations, and we'll show you that in just a second. I think that's going to be your best bet. Now, if you're in a school district where there's one superintendent, one principal, I think you're going to have to get your guidance counselor or somebody else trained up to do investigations. One of the things we're talking about is, and I think this is what we're going to do to try to help you if these rigs go through, I think we're actually going to hire somebody to work for KSB who can come in and do investigations for you on the cheap, because you don't want to pay lawyer, hourly rates for that. Because the way the investigation stuff is set up, the Title IX coordinator, I don't think can also do the investigation. And the superintendent can't be the Title IX coordinator or the investigator because he or she's the one that ultimately makes the discipline decision. So it's a mess. That's what we're telling you.
We have another question on that. Is there an issue with confidentiality or do a relationship issue with the counselor is the Title IX coordinator?
I don't have any problem with confidentiality or dual relationship if your guidance counselor is the Title IX coordinator. I have an issue with, does that person have appropriate training? Can that person really is a counselor used to doing student discipline investigations? There are guidance counselors in the state that I think would be excellent in that role. There are also guidance counselors in the state, I think, oh my gosh, he or she would be just not the right person for it. But yes, I think rolling the counselor into that administrative team of dealing with Title IX issues may be what a lot of schools have to do.
One of the interesting things that's going to come up in that regard, and we've got a case from the 8th Circuit from South Dakota actually that talks about this, is when you have actual knowledge as the school, and we'll talk about what that means, but there's a case that says when it involves teacher on student harassment, a guidance counselor cannot be the person that possesses actual knowledge, because the guidance counselor can't do anything to stop the misconduct in terms of punishing, redirecting,
Because he or she is
reassigning.
equal to the teacher
The
on
teacher.
the, yeah.
So even if we come up with a solution where we're going to use a guidance counselor, we're really gonna have to think through how that works. There could be collective bargaining implications. There could be all sorts of weird stuff, but you might have no other choice other than hiring somebody from outside or contracting with another administrator. If KSB hires like an investigator type to help all of you for cheaper, you might be stuck with one of those choices because it's not practically possible to make it your counselor. We're, again, still working.
You guys have heard me for the last 4 years saying, screw that, your superintendent can be your Title IX coordinator. I have fought hard for that because I understand that's the structure that makes the most sense under the new regs. We're trying, guys. We're trying really hard to make it work. I don't see how you, as a superintendent, can be the Title IX coordinator if the new regs go through as they're written. I don't see how that can possibly work. This is also from the 2015 Dear Colleague letter. See how I have an asterisk by job responsibilities? The assumption in all of this communication, whether it's from the DeVos Trump administration or from the Obama administration, Catherine Linehan when she was in charge of OCR, their assumption is that you have somebody whose office plate reads Karen Haase, Title IX coordinator. They assume that that's a full-time job. Now, what that looks like in Arthur County or Tri-County or, Pierce, they just don't seem to get it in terms of there are lots of schools out there where a full-time Title IX coordinator would spend most of their time playing solitaire. So this is what they expect the Title IX coordinator to do: coordinate compliance, including your procedures for investigating, and to identify proactively systemic problems that might be revealed by people coming. Like if people are constantly coming to you talking about getting their butt slapped in the locker room, that might be a systemic problem. So instead of just playing whack-a-mole and dealing with it as it comes up, you say, hey, what's going on in the locker rooms? Maybe we should have more supervision. Maybe we need to talk to the teams, whatever.
Let's go back to the investigation thing you were talking about there.
Yes.
So why can't the principal investigate even if they're not the coordinator?
Look at the administrative changes. This next slide is exactly what we're talking about. So the administrative changes require that a Title IX determination be determined by so an investigation has to be conducted and a conclusion made by an individual who is neither the Title IX coordinator or the investigator. So the way the regs have it set up is Title IX coordinator receives information that there's a Title IX problem. He or she creates a complaint or some kind of document that he or she then gives to an investigator who's not a superintendent, not the decision maker, not the Title IX coordinator. The investigator, whoever that is, goes and interviews everybody, reviews the documents. There's a whole bunch of stupid stuff that investigation has to do, including giving both parties, both kids, notice that they're going to be interviewed, letting them bring a representative with them to the interview. They have to be able to review your draft report as the investigator and review all the documents that you rely on, at least, I believe it's 10 days before the report is finalized. Then the investigator writes a report. This happened, here's my evidence, blah, 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 blah. Investigator then takes it, not to the Title IX coordinator, because remember, that's the person that started this whole process, takes it to the decision maker, who I think now has to be the principal or superintendent, and then that person decides whether or not the investigator's report is legit, and if so, what the consequences should be. So all of the administrative changes that they put together really presumes that there are 3 school people involved in every Title IX complaint: the coordinator, who reports to the investigator, who writes a report and gives it to the decision maker. And again, that's why our scheming, our best case scenario may be the 2 elementary principals cross investigating for each other, but that's why we're worried, because this whole process just is not consistent with how you have your school set up right now.
So that if they follow up, can the principal be the investigator?
The principal can be the investigator, but if you find that Cody did slap somebody's butt in the locker room, the principal then is going to be the one that imposes discipline on Cody. So that person is they're the investigator. What they're saying is it's called a single investigator model. Under the Student Discipline Act, the same person can get the complaint, investigate the complaint, enforce the punishment. And what the DeVos Education Department is saying, they believe the single investigator model is inherently unjust. And so they want a different person, they want it to look like criminal court, where a different person prosecutes, a different person investigates, and a different person is the judge. And that's the problem with this, everything we have in the state is predicated on the single investigator model. And the regulations as proposed reject the single investigator model, which means if you look at the next chunk, we're gonna have to train 3 groups of people now. We're gonna have to train your Title IX coordinator, which is you probably if you're listening. We're gonna have to train somebody to investigate, and we're gonna have to train a decision maker. That's why, I mean, yes, it's insanity. I get it. You're going, this isn't gonna work. Literally every call we get involving any kind of sex, anything, when we hang up the phone, we go in each other's office and say, holy crap, how are we gonna handle this under the new regs? Because the new regs presume an entirely different structure than we have. What were you gonna say?
Just that you said everything I was about to say.
Oh, okay.
All right, Bobby, before you get started on that, going back to the Mo Williams.
I've made you crazy. I realize that. Now I'm gonna make Bobby do the rest.
Yeah, we'll give her an over-under of about 2 minutes before she stands up again.
This is kind of related to the Williams. Are schools responsible for pictures that are being sent around outside of school during the summer break?
Yeah, good question. So are schools responsible for pictures that are being sent around during summer break, or the whole thing blows up over the weekend where the nude was shared on a Saturday night? And then even if we assume everybody has deleted it to try not to get in trouble, is that still a school issue? I think the short answer is absolutely yes. At a minimum, no, so we'll get to this in the investigation part, but keep separate in your mind for a little bit, and then we'll mash them all together in ways that make you crazy. The student discipline jurisdictional limitations and requirements compared to the Title IX requirements that you have both to the accused and to the victim with respect to the impact that that may have on both of them by their ability to access your educational programs and activities. So I think the short answer is yes, absolutely. Even if we have weird student discipline implications where we may have limitations not on school grounds, oh, look at that, less than a minute, not on school grounds, in a school vehicle, or in a school activity, you definitely are going to have school responses under Title IX.
So we had a Title IX issue last year, 2 years ago. It blurs together. 2 girls that don't go to school together are on a club dance team. And in the summer, they're in Iowa at a competition. Girl A surreptitiously films girl B in the shower and then sends that video out to all of their friends. Not a school activity, happened in the summertime. They don't even go to school together. But victim of the filming said that then she was, people said mean things about her and, you know, like thought she was like a slut and easy and whatever in school once school started. And then they filed a complaint based on Title IX. So, I mean, we could not have been less connected to school, and yet we got sucked into it. They ended up having to pay an attorney to deal with the family's complaints.
One more investigation question before you go. Can the SRO be the investigator instead of the dean of students?
Oh, so here's the problem. If you're going to have the SRO be the investigator, you've got a FERPA issue, because it's the SRO then would have to be your employee, which I think you could do because lots of times you pay half the SRO's salary, but then the SRO is not going to be able to redisclose whatever he or she discovers during the during the Title IX investigation to his or her cop buddies for the criminal. So the SRO could do school and only school, but they can't do double duty as school and cop. All right, go, Bobby.
Well, and that person also has to put together reports. So it's not that an SRO couldn't do it, but obviously what you're going to do in this case looks different than what you do for putting together a police report or some sort of standard response in that regard. So I think it's possible to take a lot of training.